when the year comes to an end, we should have an insightful session from a person very close to the teaching faculty itself. Though we have been bringing judges, senior advocates, social workers like Ma'am Vijaylakshmi, who is also very closely and passionately running a webinar series by the name of Legal Elites. And it always gives a pleasure when you connect with a person straight down south, where we can have knowledge sharing. And that's how we have all grown on a virtual platform. So we may not have met each other, not only the moderators, speakers, and the participants, but it gives you a different sense of feeling and pride. And one looks back as to how in 9 months we have touched 270 webinars, today being the 271st one. And without taking much time to introduce Dr. Vijaylakshmi, an assistant professor in SEOL, which is affiliated to Dr. Ambedkar, Tamil Nadu University. I request Adilakshmi Logamurthy, with whom we are knowledge partners, to take things forward.
Thank you, Vikas. It's such a nice, wonderful day today, and we are closing this 2020. Hopefully 2021, we will all be relieved and not arrested as we are now on the online. As you told, the virtual world was little constrained initially, but later on we all got connected only because of this COVID-19 and the virtual media. Madam Vijayalakshmi, I know her for a very long time. She was practicing law. Then she branched out into the academics, and she is one of the senior professors of law and one of the women who deals with criminal law. And her passion towards criminal law, we have to see the way she takes sessions for the students. Not only the students, even advocates, we regularly have connection with her, and she takes lots of sessions, and she has presented many papers in the international arena. Recently, on an international platform, she presented a paper on plea bargaining that was very excellent. That's how we got connected to our webinar series. And Legal Eagles Elite is so proud to get connected with Beyond Law CLC, and also with Lex webinars with Srinivasa Raghavan sir from Madurai, and so many others who are connecting us through the webinar series. Thank you so much. Even though we are closing this year, but this webinar series will continue. And Vikas is the forerunner in webinar, and he has done excellently. Hats off to him. We all keep supporting him, and we all schedule our schedules according to his sessions so that we do not miss his sessions as well. On this note, I thank Beyond Law CLC and my dear brother Vikas, and also Madam Vijaylakshmi has joined in for today's session as a guest speaker, and also the Legal Eagles Elite team who are joined in the large numbers. Thank you so much, Vikas.
Yes, ma'am, you can take over the baton. One Adilakshmi is detained, or I am arrested, I do not know, but we will hear you.
Yes. Okay. Thank you so much, sir. First, I just want to register my gratitude with my senior, Madam Adilakshmi, for referring me this platform. And I came to know that this is one of the best platforms is going on throughout the day, every day. And they are conducting various series of lectures and various series of lectures with respect to participants, those who are going to appear for the competitive exams and other things. Really, I felt very privileged today for being part of this wonderful platform. And thank you once again for Dr. Vikas sir for providing me this opportunity, because without knowing not much enough about me, sir has provided this opportunity, this platform. Thank you so much, sir. And thank you all the participants, those who are going to participate today for this. Let it be take it as a discussion instead of being a lecture. And as said by sir, today the session what we are going to discuss is about procedures relating to arrest, or understanding the legal perspective relating to arrest. I'll share the screen for sharing the PPT with everyone. Sir, will you please enable the share screen share?
Yeah, just a minute. We are live.
Okay, sir.
Yeah, let me allow.
Is it visible to everyone? So the legal perspectives of procedures relating to arrest and detention. So here, arrest and detention, what we're going to speak is not exclusively meant for the legal practitioner, because nowadays it becomes part and parcel of everyone's life to know about some basic structures regarding this, more particularly regarding the criminal procedures. We all know that recent past there are several human rights violations are happening by the hands of the police or from the hands of the public also. In such a case, how being a person belonging to the legal fraternity will be helpful in creating an awareness for that. It's only such a gist what we are going to discuss today relating to arrest and detention. So we all know that we are following the adversary system of criminal law, not as an what we are following in the common law as an accusatory system. So the burden of proof is on the state. So when the burden of proof is on the state can do anything to prove the guilt of the person who has been accused by the state. So that's what we calling the person till we are proving the case beyond all reasonable doubt. He was presumed to be innocent in the eye of law, in the eyes of the presiding officer. The court will presume the person to be innocent, and it is the state, the prosecution, who made him as an accused of a particular offense, has to take steps to prove his guilt. On the other hand, we know that being a defense side, we will try to disprove the guilt, and we are not going to prove the innocency over that. That is the part and parcel of the Indian Evidence Act, that system. So being the adversary system, the police or the prosecution here, on behalf of the prosecution, police is going to collect the evidence in favor of the prosecution or in against of the accused person. While collecting the evidence and for collecting the statements, arrest has become an inevitable procedure with respect to this investigation stage and as well as the trial stage. So why so? What is the application of arrest with respect to constitutional provisions, fundamental rights, and other safeguards provided by the apex court? It's a question to be debatable today. And we know that our criminal law has been classified into two categories. One is substantive law and procedural law. And the substantive law that we are following in India as an Indian Penal Code and Indian Evidence Act, which gives the definition and the ultimatum. So what is what? So Indian Penal Code define the offences and its punishment, and Evidence Act will define us to understand how to appreciate the evidence. So Evidence Act is the combination of substantive law and as well as the procedural law. And the exclusive procedural law is the Code of Criminal Procedure Code, where it speaks about how to execute the substantive criminal law into motion. So for example, we know the definition of theft, we know what is the punishment for theft, and if he doesn't know how to execute some matter to get the justice or remedy for being the victim of this theft or any other offense, then what is the use of having the substantive law? So the procedural law is the heart and soul of the criminal justice system, where it will execute either the penal law or the evidentiary law. So with respect to that, what are all the different types of offences we are following in procedural law as well as the Indian Penal Code, the substantive law. The broad categorization of offences is only two: cognizable, non-cognizable, bailable and non-bailable. I hope that you have come across already these things. Just to brush up things, then I come to the actual subject matter. So the most pathetic situation is that we could not find definition for what you mean by cognizable offence and what you mean by non-cognizable offence, what do you mean by bailable offence and what do you mean by non-bailable offence. So it says in the definition part, it says that it speaks about the procedure, how to deal with cognizable and how to deal with non-cognizable, how to deal with bailable and how to deal with non-bailable. But there is no exact or definite precise definition for these offences. So, but the explanation given by the CRPC regarding this cognizable, non-cognizable, bailable and non-bailable is available in the schedule, Annexure 1, Schedule 1 of the CRPC. So it simply states that offences falls within the category of cognizable offences or considered to be cognizable. Offences falls under the category under the column of non-cognizable or considered to be non-cognizable. In the same way, it says that bailable, non-bailable, and other things. So entirely we are depending upon the annexure and the schedule, and it's the answer where we can get what you mean by cognizable and non-cognizable with respect to procedural aspect is available in section 41 and with respect to the trial procedure. So today we are going to discuss about the procedures which are going to deal with arrest and detention, arrest and remand. So from section 41 to section 60 of the CRPC, we'll discuss about, deal with the procedures relating to arrest. So it includes section 41 to section 60 includes what means the procedure for arrest, how to arrest, who can arrest, what are the procedure before arrest, during arrest, after arrest, what are all the rights involved. So here it can be the fundamental rights or it may be the human rights involved for the person who is going to be get arrested. So it is a combination of all these aspects which comes within from section 41 to 60 of the CRPC. So other than the procedures laid down in from the section, from time to time the apex court is providing or granting the guidelines to be dealt with how to arrest and how should not be violative regarding the rights safeguarded by the constitution or safeguarded by the various guidelines issued by the apex court. So entirely section 41 to 60 will protect or with the intention of protecting the innocent person. It has been drafted in such a way. In other way, you could see that the entire justice system what we are following is towards the criminal justice system or towards the criminals or towards the person those who are accused as a crime, as because again the presumption of innocence. So we could find very less space for victim. More particularly from section 41 to 60 will out and out protect the rights of the person because arrest is a clear violation of the most protected fundamental right under article 21 and 22. So 21 we all know that no one should be deprived of his personal liberty unless it has been established practiced by the established procedural law. So it starts with just like an absolute rights, but the second part of Article 21 comes with the conditional rights. So it says that it is not an open-ended rights that no one shall not be arrested. Or no one's personal liberty shall be arrested. Yes, the person can be arrested when according to the procedure established by the criminal law. And more particularly, Article 22 protects the rights of the arrested person. What it says that regarding the detention of the accused person, regarding the information given to the members, those who are in connection with him, and informing the grounds for towards the person who got arrested, and it also informed the right to consult a legal practitioner, and he's having the right to defend. So Article 22 includes 4 to 5 rights which are enabled as a nature of procedure from section 41 to 60. So here it has been enlisted as a procedure, but in Article 22 it has been protected as a rights. So first rights is without delay or without being informed the grounds of arrest, the person should not be arrested. And immediately after arrest, he should not be detained more than prescribed time. And the third one is he is having the right to consult any legal practitioner. And the fourth one is to defend himself. So these 4 rights are forms parcel of this Article 22. Let us get into the actual procedures. So though it may go according to section wise, why I am going to according to section wise is that the application of one provision will have the effect of another provision. That's what we have to go according to the procedure. So 41, as I told you earlier, 41 is an answer. What do you mean by cognizable offense with respect to the procedural aspect? So 41 says that power of a police officer to arrest any person without warrant. So this was the nomenclature. This was the name given to the provision of this particular section. Power of police to arrest any person without warrant provided. So it enlisted the situations, circumstances, when and where a police can arrest a person without warrant. We all know about this warrant and summons. So it will be issued only by the court after ascertaining the fact and circumstance of the case, because where arrest is a clear violation of the personal liberty. So the procedure of arrest has to be handled very carefully. There should not be any violation of the fundamental rights protected by the Constitution. So without warrant, if a person being arrested, it has to be very much cautiously handled by the concerned police officer. And in practice, we know that police officer not below the rank of SI of police or inspector of police has no power to arrest any person. So in such a case, under what circumstances a police can arrest any person without warrant? So the first answer comes within that: if any person commits cognizable offense in the presence of the police officer. So here we can get an answer where the class 1 of section 41 itself we can get an answer. Whoever commits any cognizable offense in the presence of the police officer. So 41 deals with the cognizable offense which leads to the power of the police to arrest any person without warrant. Or if the police officer receives any reasonable complaint or credible information or reasonable suspect regarding the commission of cognizable offense, which is punishable up to 7 years or more than 7 years. So the second situation says that if it is not in the presence, if it is not been in the presence of the police officer, unless if not in the presence, if he receives any information, that information may be very credible or there may be a reasonable suspect that this person might have committed any cognizable offense, then he can be arrested without warrant. And the most important thing, even without these aspect, committing any cognizable offense or receiving any suspect regarding this, as a preventive function, because that is the primary function of every police. So the primary function of police is not for investigation. Primary function of police is to prevent. So as a preventive nature, the police officer may arrest any person without warrant as a nature to from preventing that person from committing an offense or for a proper investigation. So investigation is for the collection of evidence for the offences committed by the accused person or charged by the accused person. In such a case, when there is if the police officer involved in any of the investigating process, when during the course of investigation, if his arrest is mandatory, he can arrest the person. And the third one, preventing a person to go and tamper the evidence. So investigation is going on, investigation not yet completed, or the trial is going on. The major problem over here is that the person being an influential or the person who is in the position to go and tamper the evidence or to threaten the evidence or to induce any person to give false evidence or to turn into hostile. In such a case exists, the police can arrest any person without warrant. So other than this, what are all the procedures or what are the situations arises is that, so proclaimed offender, police can arrest any of the proclaimed offender without warrant. We know that proclaimed offender is available in section 82, where a person who continuously abscond from the investigation or for the trial or one who failed to receive the judgment, then the court will order that person as a proclaimed offender. So if any person has been proclaimed as an absconded offender by the court, then the police officer is having power to arrest the person without warrant. And the another one is, if any person is suspected or in found of any of the stolen property, the person can be arrested without warrant. And most importantly, if any person who is obstructing a police officer while discharging his duty. So discharging his duty is either he may tries to arrest any person, he may resist or obstruct, or he is trying to prevent some crowd, he may any person may obstruct or prevent the police officer to discharge his duty. And or if any person escapes or tries to escape from the custody of the police after arrest. So person got arrested and the person is taken from the place of arrest to the police station. On the way, if any person tries to escape, or if any person who escaped from the custody, he can be arrested without warrant. And this one deserted from any of the armed forces, which is something unique. So either it may be Army, Navy, or Air Force. If any person comes from the armed forces, they have to come with the warrant. So the armed Army or Navy or Air Force, the higher authority will give a warrant of leave. So from this date to this date, he will be on leave, so he will not be deserted. But if any person deserted or comes out of the armed forces without any information or permission, or after committing any violation of duties in the armed forces, if he comes out, and if any complaint has been preferred by the authority forces, then the person can be arrested without warrant. And this next one is regarding the extraterritorial jurisdiction. So offences committed outside India, but which is equally punishable in India. In such a case, if any warrant is pending or any warrant has been issued by the concerned other country through the embassy or consulate, then that person can be arrested without warrant from the Indian court. And if any person who has been released on acquitted on from the case regarding the artifice accused of artifice conduct or previous conviction. While so, if any condition has been imposed during his acquittal, and this convicted, or if this acquittal has been violated, if the condition has been violated, the person can be arrested. And if any other warrant has been pending before any other jurisdictional police station. So, for example, the concerned jurisdiction police station is Mr. X jurisdiction, and in Mr. Y's jurisdiction, the police officer has issued a notice to all police station regarding this abscond or not found, or the person who has in need of the arrest. If such a thing is waiting, and the police officer can arrest a person without warrant. So here, with respect to this warrant, we have to. With respect to the arrest, we can ask when actually arrest will take place. What do you mean by arrest? So again, there is no definition for arrest in CRPC. It says that procedure for arrest is only laid on there. The definition for arrest is not there. When we compare to any other law, the law dictionary, we can take into consideration is that it is a detention with a lawful mean. So whenever there is an curtailment of personal liberty, it is amount to arrest. So it's in 2010 in the CBI versus Kishore Singh case, the Supreme Court states that whenever a person is brought to the police station and he be kept in the lockup, it is amount to arrest. So without it is secondary. So these are all the interpretation given by the court regarding this. What do you mean by arrest and the procedures when a person can be arrested without warrant. And section 41A, 41B, 41C and 41D has been inserted from the year 2009 and 2010 by way of amendment. So this 41A was amended in the year 2009, 41B, C and D has been inserted in 2010. So what is this 41A? It gives some special powers to the police to take decision whether to arrest or not to arrest. So it says notice of appearance before the police officer. So whether a police officer can be arrested, a police officer can decide whether arrest is mandatory or not. Whether the police officer can decide whether this person can be arrested or not to be arrested is available in section 41A. So what it says, offences punishable up to 7 years of imprisonment and being a cognizable offence, and where arrest is not required. So arrest is not required. In such a case, if the police officer or the investigating officer issues any notice to the concerned person to come and appear before him at such a place and such a time for any inquiry or any investigation. So notice is a determining factor here. So depending upon the issuance of notice, if the person compiled the notice or it imposes the obligation on the part of the person against whom the notice has been issued to come and present and to comply with the terms which are being mentioned in the notice. If the person complies with coming every time to the police station or the place where it has been mentioned and he is obeying or complying with the conditions, then the person shall not be arrested. And if the person who defaulted is a notice, the person shall be arrested. So this is the power given to the police officer regarding decision of arrest or not to arrest in the matter where arrest is not required. So in some state there was an agitation against the insertion of section 41A, stating that you are giving full-fledged powers to the police. How can a police can take a decision, arrest or not to arrest? Because if you issue the notice, if they want to prevent the arrest, they can simply come and comply the condition. On the other hand, it was been alleged that it is affecting the advocates also. So the procedure for bail and other thing. So later only it came into effect. So this is section 41A. And 41B is the procedure to be followed while making arrest. So during arrest. So every police officer, those who are arresting any person, they have to follow. It imposes a duty. It is the obligation of the police officer while making arrest of the person. So first one, what it says that the name badge should be visible to the arrestee. So the person who is going to be arrested should have a visible indication regarding the name of the person who is arresting him and his designation. So the name badge should be very much visible to the person, and the police officer has to prepare a memorandum of arrest or arrest memo. So this was the outcome of D.K. Basu versus State of West Bengal case, and the another one is Joginder Singh case. So the guidelines issued by the Supreme Court has been amended by way of procedure here. So arrest memo is a printed form where it includes the information, the entire information regarding the arrest, name of the accused person, crime number, which police station, what are the charge or the offense made against the person, where he was arrested, when he was arrested, whether anything has been seized from him, arrest information to be given to whom, who was the nominated person, whether it has been signed by the arrested person. So all these information has to be recorded in this memorandum of arrest. It has to be signed by the arrested person, and when it is going to be served, to be given to the person, informed by the arrested person to whom it has been, what we call as nominee. And that person has also to be signed as an attested witness towards the preparation of the memo. And information, informing the arrest to the friends or the family members or the relatives or even advocates or any other person nominated by the arrested person. So arrest should not be informed to just to the family members. Whoever want to be informed, that person should be informed according to section 41. And 41C is control room. So establishment of control room in every district and every state level. So control room is not simply giving information regarding the commission of the offense or getting information regarding the about the police station. It says that control room is at the obligation to display the name and addresses of the arrested person in that particular district, and also the name and details of the person who arrested the person. So name and details of the police officer and name and details addresses of the arrested person should be displayed in the control room, and the control room has to collect the details from time to time, including the nature of offense, and they have to maintain such a database, because nowadays it is very much clear regarding the RTI. Every time we are being asking for how many person has got arrested, and who arrested the person, at what time he got arrested, what time he was brought to the police station. So all these things should be maintained only by this control room. And 41D is the most important right. It gives the arrested person to have the counsel with him, an advocate with him, not throughout the interrogation, or at least during some time of interrogation. So during some time of investigation, if the arrested person wants to have an advocate with him, he is permitted. So this right was not even given to the victim. but this right was given to the arrested person because it has to check it out, because the first 15 days of the interrogation period is very much crucial, because during this time the police may get any, or the police may record any statement or confession or seizure. So to avoid this, they are permitted to have the legal practitioner with them. And section 42, it is arrest for some other purpose. So 41 is for this purpose. Which one? Cognizable offense. And 42 is for not to remain silent. The right to remain silent is not a recognized right in our country. So it may available in UK, it may available in other Western country. So whoever refuses to give the name and details under the obligation of the police, if police during the course of investigation, or if the police wants to get some information from any witness or any person who refuses to give the name and detail on demand of the police officer, it is an offense, and for that offense the police officer can arrest the person. So here he may be the person of a non-cognizable offense also, not exclusively specifically regarding this. But once the information has been ascertained, so whatever the information they want to get from the person, once the person after arrest gave the information, immediately he shall be released on his own bail or own bail bond with or without surety. But once they get the information, they have to be released immediately. Or if they fail to get this information within the stipulated time, then according to section 167, the person has to be produced before the magistrate, and the magistrate has to send the person for the judicial custody or something else. So section 42 will not happen all the time. It is under a very rare occasion it will happen. And 43, 44 and 45 speaks about arrest other than police officer. So section 41 or the general arrest procedure says that only the police officer not below the rank of inspector of police having the right to arrest. But section 43, 44 and 45 speaks about arrest by other person like private person or the magistrate. So every individual is having the right to arrest. Even you and I can also arrest, but not actually having the arresting the person by having handcuff, this and that. But the law gives the power to every private person. When the person can arrest is, one is when in front of me, in my presence, if any person commits any cognizable or non-cognizable. So private person, why they give this freedom is that because being a layman, I don't know what is cognizable offense and what is non-cognizable offense. So according to me, everything is an offense. So any person who commits any cognizable or non-cognizable in my presence, and the person being a proclaimed offender. So proclaimed offender, I could witness a proclaimed offender in public places, in railway station, in metro station, in bus stop, or any other gathering, in the court, everywhere. So I already saw this person as a proclaimed offender. So when I came across that person, I can arrest the person without any warrant. But what it says that once you arrest a person, you should not detain the person with you. Immediately you have to produce the person to the nearest police station or to the nearest executive magistrate. So either it may be 42 or because 42 covers the name and the designation of that person. Being a private person, we can't have it that. So the person has to be, without any delay, should produce the person to the nearest magistrate or to the nearest police officer. This is the powers of the private person. And with respect to the power of the magistrate to make arrest. So magistrate, because arrest falls part and parcel of the investigating procedure. So investigation being the sole power of the police alone, magistrates has no power to arrest. They may order to arrest, but they can't arrest. But section 44 give rights to the person, to the magistrate to make arrest when, again, in his presence, if any person commits any offense in the court, when he is behaving in the judicial capacity, when he is discharging his duty in the judicial capacity, when he is sitting in the court as a magistrate, then he can make an arrest, or else he will become a private person. And if it is not possible, or order any other person to arrest that person and commit him in his custody. produce him immediately into his custody. And 45, as we discussed in section 41, any person who is deserted from the armed forces can be arrested without warrant. And 45 gives some immunity to the armed forces. When is that? When a person who is discharging a duty in his official capacity. We can see several paramilitary forces, several military forces, several armed forces has been employed and deployed during the election period, during a grand ceremony of any gathering, or during any riot. So at the time, they are only discharging their duty, and they are not committing any offense. Though they commit any offense while discharging their duty, any shoot at sight, or we could see this disbursement of mob when there is an unlawful assembly. So if any 144 has been ordered, now we are just facing this lockdown. Gradually the curfew and the lockdown, the conditions are being relaxed. But initially when the COVID-19 is at peak, there was a strict rule that no one should come out. So that time the government has deployed the paramilitary forces to come and discharge their duties. In such a time, if they commit any offense means if they cause any injury or if they commit anything, it will not come under the offense and they cannot be arrested. And if it is so, no other go, the person shall be arrested, then it has to be done only with the previous sanction of the armed forces or from the union government. So this is the immunity given to them. And 47 is search of place. So search of place is not of something which speaks about search and seizure. So here the person who has been found to be in the harbor. Harboring means giving shelter or concealing any person, or when the police officer tries to arrest any person, he escaped from his custody and he entered into some place. Now he has been in some establishment or in any residence or at any place. So the police is having such a suspect that the person has entered into this building and tried to evade the arrest or tried to escape from the arrest. In such a case, the police can search the person, and if a person who is in charge of that particular place shall obey or shall facilitate the police officer to take arrest of the person. So this we already came across in this search and seizure, how to conduct search with warrant and without warrant, general search and specific search, all these things here. Here it is a specific search, not the general search, because it is a search of a person who escaped from the arrest and he is found in his particular place. So if any person who is not allowing the police officer to enter freely, or if any person prevent any police officer to enter into the place, then the police officer can use force to break open either the outer space or the inner door or window or any other place as a pathway, and they can enter into the house or the place where he hide himself, and he can be arrested. And if it is the place or the establishment or the residence is being occupied by a female, and the police officer, before entering into the house, they have to give notice to the female, and if the female permits, then only they can enter into the house, or else the female police officer should be employed to conduct this one. And so section 46 speaks about arrest how made. So arrest how made is that we usually come across several movies. The police officer will come and they said you are under arrest. So this is not amount to arrest. So arrest is that the person should defaulted or the person should deprived of his personal liberty, which means he could not move from that place. So his personal liberty should be curtailed. It is arrest. So, and it is not mandatory that the person should be handcuffed also. So what the law says that you actually touch the person and confine the person into the custody. So you take the person into your custody. His free movement should be curtailed. It is the actual arrest. So not simply uttering the word or not simply showing the handcuff or not simply putting the handcuff is not an arrest. His free movement should have been curtailed there. It is the procedure for arrest. And in 2009, after the various guidelines issued by the Supreme Court of India in Christian Community Welfare Association or Vellore Welfare Association versus Union of India, they gave the guidelines regarding arrest of women. We all know that no woman shall be arrested before sunrise and after sunset. But no other go, it is very much mandatory or it is necessary to be arrested. That woman has to be arrested. Then a women police officer should accompany while taking arrest of a woman after sunset and before sunrise. Even after arrest, unless it is mandatory, he should not brought to the police station, kept in the lockup. So all these things should be followed in case of women. And harass how made, which includes usage of force also. While taking arrest, whether a police officer can use force. The law says yes, you can use force. But what is the extent of using that force? So, to what extent the police officer can use force over here? Force of taking arrest, which is proportionate towards the by the arrested person who is going to be arrested. So, suppose the person tries to escape, whether a police officer can shoot the person. The police officer has to say, my life is at danger. Whenever there is a threat to life, while using the right of private defense, then a police officer can go to the extent of causing death of the person against whom he is going to be arrested. And that too, that person should be charged with an offense which is punishable with death or imprisonment for life. If it is not, then the police officer should not use the force which may go and cause death of the person. So proportionality. So what is the proportionality? What is the level of extent of escape made by the accused person, and what is the level of the defense used by the police is very much mandatory over here. This is the place where all encounters are being handled. Arrest how made, law gives the power, usage force, but that usage of force is not an absolute power, it is a conditional power. You should not extend, you should not exceed the power of usage of force which may cause death unless otherwise it is being justified, or else the person can be charged with offences which are punishable in the Indian Penal Code. And section 48 speaks about pursuit of offenders into other jurisdictions. That's what I told you. So person those who are in other jurisdiction, if any warrant is pending, then he can be arrested. And section 49 and 50 is most important rights, and this right has to be or procedure has to be very strictly followed. When this is a right, the person, this right is not known to everyone, or not, there was no awareness regarding this particular rights. One is unnecessary restraint, another one is right to know about the grounds of arrest and bail. So unnecessary restraint is that the restraint must be within the limit to prevent his escape. If the person shows cooperation to the police officer, he not to show the restraint. If the arrested person shows any restraint, then only the police shows any steps or taking anything to escape, then only he has to restrain. So this is section 49. That what it says that handcuffing. It is indirectly speaks about handcuffing. So handcuffing shall be prevented to the maximum unless there is no scope for escape. And 50 speaks about the grounds of arrest and bail. So we came to know, or we are all know that these rights will be informed in the first remand report, the first remand order. But according to the law established by the CRPC, it is the obligation of the police officer who is making arrest has to inform two rights. One is that you are being arrested for so and so reason, informing the grounds for arrest, and that has to be informed who gave the complaint, what is the crime number, which police station the crime number is pending. This has to be informed. And another one, immediately, if the person being arrested for non-bailable offences, then he has to be informed he is having the right to be released on bail And if it is being a bailable offences, he has to be informed. If he is ready to furnish surety, he can be released on his own bail bond. So it's a general presumption that only the court will inform, the magistrate who is passing the remand will inform that you are being arrested for this and this ground, you are having the right to bail, but this has to be informed at the time of arrest itself, and it is the obligation or duty of the police officer who is making arrest. And section 50A. This has been inserted in the year 2005. As I told you, it's a right to nominated person to whom the arrest information shall be provided, shall be served. So here, generally before 2005, arrest information will be informed, shall be informed only to their parents, either the family members, father or mother or brother or wife or spouse, to them only. But what had happened, meantime, so they, being an illiterate, being a lay person, they don't know what to do with it. So to avoid this unnecessary detention in the police station or in the lockup, in 2005, what it says, let it be the rights of the arrested person to state to whom the arrest information should be served. So if the police, if the arrest person states that inform the arrest information to the advocate, means he is the nominated person. So he immediately come to the police station, and because he knows whether it is available or non-bailable, or he may come with ready with the bail order also. So it says that it has to be again informed by the police officer, who the person who is arresting, that you are having a right to whom your information shall be served. So any person can be informed, and the person should also be informed regarding the place where he has been kept, not only the arrest information, the place where he has been kept, either in the police station or any other place. Above all these things, this has to be entered in the general diary, GD, according to section 171 and 172 of the CRPC. So general diary is the most important document which having the evidentiary value as a corroborative evidence, because it is the information to be recorded the each and every day movement of a particular police station. Every police station should maintain a general diary. It has to record how many arrests has been made on a particular day, how many person came for signing as a bail condition, how many complaints has been preferred, how many investigation has been completed, how many arrest information has been given, who are the person on duty on that day, any confession has been done, any identification parade has been done. So each and every information or each and every activity of the particular police station has to be recorded in the general diary. While so, the information regarding the arrest, the information regarding the nominated person, information regarding the person where he has been informed has to be recorded in the general diary. So during the course of trial, if I want to take a defense that it has been violated, I can ask the person, police officer or the prosecution, to come and produce the general diary under section 91 CRPC or section 311 CRPC, producing certain documents for the trial procedure. And the general diary has been forwarded to the concerned jurisdictional magistrate for his satisfaction regarding the arrest is justified or not. So each and every day this has to be informed to the concerned jurisdictional magistrate also. So this is 50A. And 51 is search of arrested person. So immediately after arrest, once the person brought to the police station, before keeping the person in the lockup, the person has to be searched. So this is a prisoner search or the arrested person search. So what it says that, so once a person has arrested, so he should not be, he should be searched. Search means what? He has to seize the material from him, any valuable materials, or if he is having any offensive weapon, or if he is having any other mobile phone or anything, it has to be removed, seized from the person, and their list has to be prepared. It has to be signed by the person from whom it has been seized, and it has to be handed over to the person who has been nominated for the information. So this search of the arrested person is also having another ambit to check out the person if he's having any other injury on his body. If it is there, then the person has to send for medical examination, which will come in the next provisions, other provisions of the law. So to seize the offense, to seize the valuable materials other than the wearing apparel, the attire, all other thing has to be seized from the person, because we came to know that some person are committing suicide inside the lockup with having any sharp-edged weapon, or they having any matchstick or any firearms with them. So to avoid this has to be done, and seizure memo has to be prepared, and it has to be signed, and it is to be handed over to the concerned family member. And if it is being a person of person arrested is a female, it has to be done by the female police officer with strict decency. Though it is being conducted by the female police officer, it has to be conducted with strict decency, because in Tamil Nadu we came across several cases where some women are committing suicide inside the police station itself due to the indecent way of conducting this search. And 52 is continuity toward the 51, seizing of this offensive weapon. Those who are having any deadly weapon or any other offensive weapon, it has to be seized. This is section 52. And once this weapon has been seized, it should be immediately referred to the court having the jurisdiction. And 53 is, as I told you, it's a medical examination at the request of the police officer. So here we could see two medical examination. One is at the request of the police officer. Another provision we will discuss, that is at the request of the arrested person. So here 53 at the request of the police officer. So after the search, the prisoner search or the arrested person search. So if the police officer thought that if the person would have been went for medical examination, he could have get material, some admissible material, evidence material from him, then the person can be taken for medical examination with his consent to the registered medical practitioner. So the registered medical practitioner is nothing but the person who has been registered according to the Indian Medical Council Act or Indian Medical Council Regulation Act. Those who are being registered under this, and the person should be working in a government or local body undertaking medical center or the hospitals. So here this medical examination is only an examination and should not take any sample, because it is violative of Article 20 subclass 3. That is a self-incrimination. But if the person consented, then he will be taken for, the samples can be taken. Otherwise, then simply medical examination and the report of the medical officer is enough. And being a female, that has to be followed. And as I told you, medical examination includes with the consent and without causing any incriminatory aspect. It includes examination of blood or blood stain, being a murder case or being an voluntarily causing grievous hurt or sometimes sexual offences case, and semen swabs in sexual offences case, sputum and sweat, hair sample, fingernail, other thing for the purpose of DNA profiling. Because now we have been moved from traditional method of conducting investigation to the scientific method and modern scientific technique method of investigation. So for DNA profiling, if it is a case of legitimacy of a child, or if it is being in sexual offences, so this can also be done. And as I told you, RMP means possess any medical qualification under the Indian Medical Council Act. So this is at the request of the police officer. And 53A, it has been inserted again. This is exclusively medical examination of an rape victim. So this was inserted in the year 2005. So it is the examination of the rape accused. So immediately after arrest. So it may be the offense of rape or attempt to rape. So attempt to rape, we can take the help of sexual harassment now, section 354A and B. So if any two of these offences, and again, there must be a good belief or reason to believe by whom? The investigating officer. If the person would have been sent for medical examination, he might have get some evidence. In such a case only, the person has to send for medical examination, and it has to be conducted by the registered medical practitioner. without any delay, the RMPs has to prepare a report, because delay is a very big challenge in sexual offences cases. So either it may be medical examination, either it may be collection of evidence, either it may be getting a report. So day by day it will reduce or dilute the intensity of the case. So the law imposes the obligation the medical officer without any delay has to prepare the report, where the report has to consist of the details about the person who underwent the examination and what are all the injury marks present in the body of the person, and material taken, which means what are the samples taken from the person, and any other material particulars, if it is reasonable for the purpose of the conducting of this examination, has to be prepared. And they have to give the conclusion also, whether he is because sometimes they will make a defense that the person is not competent to commit such an offense. So they have to give a report, because when we are in practice, I came across a case. It's a sexual offense, that is a rape. The man was nearly 85 years old. That man raped his own daughter. The daughter gave birth to a child also. So when a complaint was given by an NGO, the defense taken by the father's side is he was 85 years old. He was not possible to commit rape on the daughter. So he was went for the DNA and other tests, and the DNA report precisely gave the conclusion the person is 99% eligible to commit the crime. So the conclusion plays a vital role in some cases. So it has to be very precisely give the conclusion, and it has to be forwarded to the magistrate for the purpose of closing the investigation or concluding the investigation. And 54, it is the request of the arrested person. So first one, 53, we see request of the police officer. 53A, medical examination of a rape accused. 54 is medical examination of the arrested person on his request. So this is the situation where the person will come and show that he has been harassed or he has been tortured, he was being injured, assaulted by the police while taking arrest. So he want to show at the time of producing before the magistrate. So if he requests that he want to go for any medical examination, medical treatment, he has to be sent for that. And if there is any injury report or injury mark is there, it has to be given by the concerned medical practitioner. This is 54. Whenever if the accused person wants to create it as a document, he can ask for medical examination. And 54A is identification. So conducting test of identification parade. Again, this is also been included in their only 2009. So what it says, test of identification parade is if any person who has been where his identification is necessary, because there was no proper or there was no clear conclusion that whether this person or some other person. So the victim is ready or the eyewitness is ready to identify. So at the time, this test of identification parade can be conducted at the request of the police officer to the nearest jurisdictional magistrate, and the person has to be identified. So we all know how they will conduct test of identification parade. Before conducting of this identification parade, his identity should not be revealed anywhere. Either his face, name, or any other detail should not be revealed anywhere, and that must be the first time the witness is going to identify him. And the person who has been set up for the test of identification parade shall be with the same resemblance of this particular person, and twice or thrice the person has to be identified. So all these things comes within this section 50 and section 50. 54A, identification parade. And 55 is dispute subordinate to arrest without warrant. So this is nothing but if any person who is not up to the rank of inspector of police or SA of police, if they may got arrested, what is the procedure? 55A is again, it is also one of the important procedure and rights. The person who is taking arrest, it becomes his obligation to take care of the person till he has been produced before the magistrate. So for the 24 hours, he is responsible for this person. If anything happened to the person who makes arrest is responsible for him. So he has to provide food, proper facility, not facility in the sense not providing anything, but without causing anything to him, he has to take care of the person till he has produced before the magistrate. So this person will become liable when anything happened to the person during this 24 hours, during the custody of the police. And 56 and 57 speaks about how many hours the police officer can detain the person, because according to section 56 and 57, one, it says that without unnecessary delay, another will state that 24 hours. So here what is the difference between these two is that 56 speaks about jurisdictional magistrate without unnecessary delay. So arrest person shall be taken before the jurisdictional judicial magistrate without any unnecessary delay. And what is this unnecessary delay? How we can interpret the unnecessary delay? Where is the answer for the term unnecessary delay? Then what is necessary delay? Hours, it is available in time given, is the power given to the police officer to retain the arrested person with him if the from the time of arrest, not the time when he brought to the police station, to conduct the investigation used before the magistrate. So this is, and here it says that not there. And 57 it says the near arrested in some other place, excluding the traveling time, other thing will be taken into consideration. So 56 answer 57, and 58 is releasing a person if being an available offense. So if it is say if the person who is being arrested for a bailable offense, he can be arrested. That person, if he is ready to be released on bail, which means he is ready to provide sureties or securities, then he can be released, immediately discharged from the custody. So here it says that except his own bond. This is for this it is available in section 436 of CRPC, bail for a bailable offences. So 436, 437. 437 is non-bailable offences, 436 bailable offences. So 58 speaks about discharge, and 436 how to discharge is available. And 59 is retake, nothing but if the person has been escaped from the custody, escaped from the clutches or from the detention. If he has been rescued, arrest again, he has to be re-arrest again. So re-arrest is that because once he has been escaped, that warrant has been abolished, then again he has been shown arrest, then the time again start to run. So this thing once comes within section 59, and section 60 speaks about this is section 60, and section 60A, which says that from section 41 to section 60, these are all the procedure which has to be strictly adhered. So arrest is not an power of the particular person or the police officer to be enjoyed, but it has to be strictly adhered. If anything violated, it is the violation of Article 21 and 22. So action can be taken against the person. So here only we can challenge any of the unlawful detention. Section 60A is the answer for how can I get a remedy to show that it is violation, because 60A says that it is obligation to follow the procedure. If it is violated, if it is an unlawful detention or unlawful arrest, I can file any petition and I can ask for the compensation into it. And it is the continuation toward this arrest procedure, because 56 and 57, I told you, regarding within 24 hours, what would happen? So after the lapse of 24 hours, what should happen? What is the procedure? Because okay, 57, time is going to lapse. So that answer is available in section 167 of CRPC. This 167 of CRPC is a golden principle. It speaks about mandatory provision. So what it says, So within 24 hours, when you are not able to conclude the investigation, immediately produce the person to the nearest magistrate. This is class 1. And once the magistrate receives the accused, once the receives the arrested person, what the magistrate has to do? It will come in 167. What it says, once the magistrate receives any person produced by the police officer, first of all, he should not refuse to receive based on the jurisdiction issue, because 57 gives the power to all the magistrate to receive any person after arrest. So he has to receive and send the person for the judicial custody not exceeding 15 days. So this is the first remand. Date of arrest 24 hours, lapse of 24 hours, producing the person under section 167 class 1, and under section 167 class 2, the magistrate has to send the person to judicial custody for 15 days. So this 15 days or the first remand is having several issues in it, because in the first remand order, the magistrate has to ascertain the remand order itself whether the procedure has been properly carried out by the police officer. The magistrate has to question the person produced before him. One, whether the grounds of arrest informed to you. Have you informed the grounds of arrest? Have you informed that you are having the right to be released on bail? Have you informed the right to be having the free legal aid? Whether the police tortured you, any third degree method has been imposed upon you, whether you want to go for a medical examination, all these things should be ascertained by the magistrate with the arrested person, and it has to be effected in the first remand order. It should be in writing, it should be in recording. And again, another one more important aspect of this first remand is that the police can ask for police custody within this first remand order. Within this first 15 days, if the police come and satisfy the court that if I take the person into my custody for further investigation, I could get more information. And if the magistrate satisfied, the magistrate can also give the police custody. This is the ambit or the nuances of the first remand. And we can ask what would happen after the lapse of 15 days. It is available in class 2. It says that once the 15 days is get over, another 15 days the magistrate can extend at the request of the police officer. And how long it can be extended? It can be extended for 90 days or 60 days. 90 days if the case relating to anything which is punishable up to death or imprisonment for life or imprisonment not less than 10 years. And 60 days for other offences. So the extension may go like this: 15 days, 15 days, 15 days extension may go like this for 90 days or 60 days according to the nature of the case. Okay, another question. What would happen if on the expiry of this 60 days or 90 days? Here is the question. Answer says that it becomes a mandatory bail. The magistrate has to release the person on bail at once if the person is ready for that, with the condition within the 60 days or 90 days, investigation has not completed, final report has not been submitted. If it is there, then irrespective of the nature of the crime, though it is an offense of punishable with a death sentence, though it is an offense of murder, though the magistrate is not empowered to release the person on bail under section 439, but according to section 167 subclass 2, if the investigation is still continuing and the person is still languishing in prison, if the days is over, then he has to be released on bail. And with respect to the executive magistrate, the concern 167 itself. So why I continued with the section 167 is that it is a continuity of section 56 and 57. So these are all some of the important cases with respect, though these are all the old cases, still it plays a vital role. Still it plays an important role in rights of the arrested person. Each and every case, without citing these cases, there won't be any judgments or guidelines regarding the arrest. And Joginder Kumar case and Dilip Kumar Basu case, as I told you earlier, preparation of arrest memo, control room, display of the name or visible display of the name badge, or everything comes out of these two. And the Christian Community Welfare Association case, as I told you, it is a case which gives way for the implementation of or the amendment of procedure for arresting of women. And Nilabati Bera was the state of Orissa, the rights of the arrested person and the obligations of the police officer. So this is regarding the recording of statement during the time of arrest should be prevented, that one. And Madhulimia case, Article 22, and regarding the basic rights and basic obligation to inform the grounds of arrest. And Sheila Barse, several bill has been filed by Madam Sheila Barse, and under this is regarding medical because this particular case relates to women prisoner and children inmates into time, but interpretations I hope that covers this section 41 to 60, and if it goes again and again, we have to be very clear regarding three important things. So one is, we all know very well about the time of arrest, without delay, 24 hours, all these things. But other than that, we have to be aware that control room, the procedures related to control room, and the visible identification of the person get arrested, and the obligation of the police officer to take care of the person till he is in his custody, and informing the rights of to bail, and informing the grounds of arrest and the nominated person, and having an advocate with him till the interrogation has been complete. So with this, I think we can wind up. Okay, already some questions has been posted in the chat box because I shared the screen. I could not.
Yeah, ma'am, I'm taking it.
Okay. Yes. Okay, Article 21, Clause 1. This is by Mr. Naveen Kumar.
22(1).
The Constitution reads no person arrested, but what police would generally do is detain the person without arrest being made, thus bypassing the constitutional provisions cases. Refuse to go to the police station if called on. Yes, sir, because here how to deal with these cases. Once you came to know about that any person has been taken to the police station without proper arrest, immediately send a telegram to the superior police officer. There you are creating a document that the person has been illegally or unlawfully taken into custody. So that will speak a vital role. Or immediately file an habeas corpus petition with the help of this telegram. I gave a telegram, I made a representation, it was not properly considered, I visited the police station, my son or brother or no one is there, I feel that my son's life is in danger in the hands of the police. Till date, his whereabouts were not known. I gave a telegram was not properly considered, file an habeas corpus petition. With respect to the second one, when a person can refuse to go to police station, if called, that is the section, that is the nuances of section 41A. So that's what we are all agitated when we are reverse in practice. We are all agitated. Why are you giving such an extensive power to the police? Because you say that arrest is not required. When arrest is not required, why you are making the person to come to the police station for inquiry? But what the law says is that most of the time, the 7 years cases, sometimes it may be the matrimonial dispute, more particularly section 498A and Dowry Prohibition or Dowry Prohibition Act, we could settle the matter in the police station. That's what we are calling the person to the police station for the negotiation. But it says it use the term shall be arrested. If the person failed to appear before the police, he shall be arrested. But what we can do when we are going to the police station for the compliance of section 41A notice, go along with an legal practitioner, with a counsel. Is it criteria under section 41B? CRP is also required to be followed in 41(1)A. Why not if the offence is punishable up to 7 years only? That's what I'm telling. So 7 years are the criteria regarding the section either 41A or 41(1)B is that more than 7 years we are coming across another case also, summons and warrant case. It speaks about the seriousness, gravity of the offense. So if it is more than 7 years, and even if it is there is no sufficient time to get warrant or something else, and being a seriousness and gravity of the offense, arrest is immediately necessary required. So that's what he is being arrested without warrant. Procedure and prevention under section 82 in application of CRPC. Okay, so 125. Okay, this speaks about the maintenance with respect to proclamation. Maybe this is 83 may come, sir. Attachment may come. Proclamation may not come. Attachment may come. Attachment of property. If the person against whom any maintenance order has been passed under section 125(3) CRPC by any family court or the magistrate court, and if the person failed to pay such a maintenance, then the court may attach the property. So here to prevent is that we have to come up with such a situation that either the person is eligible to pay the maintenance, whether he is having such a means to pay maintenance. That is the thing where you can, whether the recovery come warrant is pending and not returned, can be application of warrant under section 82. So if warrant is pending, if whether it is a bailable warrant or non-bailable warrant. If it is a bailable warrant, we can appear before the police station and we can execute the warrant. If it is a non-bailable warrant under section 70 of class 2, we can surrender before the concerned court in which court the warrant has been passed. Or we can take the help of anticipatory bail under section 438. You can prevent arrest or execution of this warrant issued against the concerned person. What is the procedure for the medical examination of victim of offense other than rape? Example, grievous hurt. Sir, that's what I told you. CRPC or the criminal law is totally towards the accused. Protection of accused rights, protection of human rights of the accused. We are totally forget about the victim. We totally forget about that. At the end of the day, we are going to provide justice to the victim, and we are not giving proper space to the victim in the entire procedural aspect. So even if I want to go for the medical examination, if it is rape, as I said, it is available there. If it is other than the rape or grievous hurt, we have to be inform the police, and if the police want to take us, they have to take it to the concerned government hospital, and the government hospital has to issue the injury report. So either a grave injury or a simple injury or whatever the injury may be. So this is the one of the major, that's what I presented my paper on plea bargaining, where plea bargaining is one of the limited provision which gives space for victim. Then I have transferred 300. I'm sorry. Okay, I will share the PPT with the coordinator and the sir will share with you. Lady victim died of sexual assault or by hanging. Procedure for
unmute kar, ma'am. Ma'am, you will have to unmute yourself. Vijaylakshmi ma'am, you have muted yourself.
Yes, sir.
Yeah, you will have to unmute and repeat what you had said.
Whether it is audible now?
Yeah, you had muted yourself for around 30 seconds, so you will have to repeat that part.
Oh, sir. Okay, I will continue again. So, either it may come under section 174 of CRPC, unnatural death, or under section 176. So here, whether it is a case of a death of sexual assault or hanging by herself, hanging by herself will cover under section 174 and 176. So immediately, information has been given to the nearest police station. Police has to come and take the body, because it is not known whether it is actually by hanging or somebody has murdered the woman and then hanged her. So it will cover only under unnatural death or suspicious death. After then, the police officer, by getting, this is called inquest. 174 and 176 is called inquest. they have to conduct a preliminary inquiry over the deceased person, and they will forward the deceased corpus to the concerned government hospital for conducting the autopsy with the proper report, and the medical officer who is going to conduct the autopsy has to receive the report from the police officer, and first they have to give the marks on its face, whether the body is found rigor mortis, any other injury is there, how the body looks like, whether it is an immediately dead body or it is an partly decomposed dead body or any other decomposed body, that has to be informed, what would be the age and everything. Then he has to commence the autopsy. It has to be recorded at what time the autopsy has been commenced and what time it has been concluded, and all the reports has to be followed. This is in case of for sexual assault also the same, sir. Female arrested after sunset in NDPS. Sir, we cannot, that's what I forgot to tell that. In NDPS cases, it is, the act is having its own procedural aspect. The CRPC is a general law, but whenever there is a special procedures involved like arrest, search, seizure, bail and trial, we cannot take the help of this CRPC because NDPS having these procedures within it. So we have to follow the NDPS procedure. Medical examination of lady victim. (125) If the court gives direction to the jurisdictional police station for attachment of mobile, can they insist the arrested person? For 125, court will not give the attachment order to the police station. Execution order for taking arrest of the person, then the family court will give the order to the police station. For attachment of property, it has to be executed. The way of execution has to be informed by the family court presiding officer itself. Police cannot insist the arrested person to attach the property because he is having his own remedy how to overcome this, the attachment order. He can challenge that also. Till date, most of the poor people suffered long time standing or sitting without any process or progress in the police station in the name of investigation inquiry by the police. How to prevent unnecessary waiting before the police station? So I don't know whether this question has been asked from the perspective of the victim or from the perspective of the victims or from the perspective of the accused. There are limitations in concluding the investigation. If it is not concluded, we can file a petition under section 402 CRPC seeking direction from the High Court to complete the investigation at the earliest by the police. Or else we can ask to change the investigating agency from the crime branch to CBCID or any other police wing. We can ask under section 402 CRPC inherent powers of the High Court. Okay, I hope that I covered all the queries posted by. Okay, I think so. And thank you everyone for your patience and being over here even at the verge of this New Year Eve. You all been unknown body found on the land. I told you, no sir, this is 174. 174 is unsuspectable death or unnatural death. We don't know the body, who is that man, whether he belongs to that particular locality, whether he has been murdered or whether he committed suicide, nothing was known. So at first, police will register a case only under section 174. After conducting preliminary inquiry, then only they will convert the case either into either suicide or murder. Yes, Nikita Modi advocate, you can type your question here. Making arrest without issuing, unless if it is an situation falls under section 41, police cannot arrest a person without warrant, sir. Either 41 and 41A must be there. Other than that, police cannot arrest any person without warrant. Under section 217 of CRPC, it has to be justified. That's what I'm telling you. So if the facts and situation determines it has to be justified before the magistrate court why the action has been taken under section 217 of the CRPC. If you read the provision, section 217 of the CRPC, you could get an answer. Just a minute, I'll just read out the provision. So section 217 is recall of witness when charge altered. So the section 211 to 220 speaks about framing of charges and alteration of charges. So when a charge is altered and the person who was not being called as a witness, and now after the alteration of charge, he becomes part and parcel of the case, of a particular case. So he can be called again. If he refused to appear, again it is an offence under section 186 of IPC itself, disobeying the lawful summons or warrant by the court. That time it can be or cannot be. What if the police files a report which is not favorable?
You are unmuting her, ma'am. You are unmuting Nitika. She will come on the video.
Okay.
She wants to ask a question directly.
Okay, so I'll just read out the another question, sir. What if the police files a report which is not favorable to the victim, and in case like dacoity charges? Yes, madam. Suppose if you are not satisfied with the report submitted by the police, you can again challenge the report submitted to the police by way of section 482 CRPC, because you can come and state that the investigation has been conducted biasly, it was not been properly considered, and I want to change the investigating agency, or said by Mr. Naveen Kumar, protest petition will be filed only if the complaint has been closed. I gave a complaint and I asked to conduct, I am expecting the remedy, but the remedy was not properly given. It has been closed as civil in nature, land dispute, this and that. So my complaint has not been properly investigated. So my complaint has been closed. I can file protest petition. But here, if that investigation report is not satisfied, we can file under section 482 CRPC, because protest petition you have to file before the judicial magistrate court. 482 we can directly file it before the high court itself by putting forth your grounds.
Thank you, ma'am.
Not issuing notice is not an offence. Not issuing notice is not offence under section. Chandrasekhar sir, whether not issuing notice in the sense notice to come and appear before the court, or notice for what, sir? Summons, are you mentioning about the summons here? Section 217. No, not issuing notice is not an offence, but you have been called as a witness. That's what I mean. Charge has been altered. While submitting the final report, while charge sheet, that charge is something else. Based on the charge, charge has been framed. After the framing of charges, the trial is going on, we know discharge. That person has been discharged. But once the trial commences, some witnesses again speaks about the charge from which he has been discharged. Again, it has been altered, because charge can be added at any time of the case before passing judgment. In such a case, the person who has been witnessed, examined already, he can be recalled again. So section 311 is the prosecution or by the defense at any before the commencement of the judgment. But here, based on the alteration of charges, the person can be recalled again. So to recall or resummon, examine with reference to such alteration, any witness who may have been examined unless the court, for reason to be recorded in writing, considered that the prosecutor, the accused, as the case may be, desires to recall or re-examine such witness for the purpose of vexatious delay. Also to call any further witness from the court. So here, it says that if a accused person is calling that person, he may call that person to come and prove this altered charge has been made with ulterior motive, to prove that. For the prosecution side, if any witness has been recalled, it is their side to prove the altered charge is having prima facie. This is the ground for that. And ma'am, I asked in my question above, in case of execution of petition under section, a recovery cum warrant is pending in process and an application is made for warrant of proclamation. Yes, this can be objected. Yes, this can be objected because proclamation has its own limitation. Proclamation says that who has been absconded, who has not turned up for the investigation, who has not been turned for receiving the judgment. So this is proclamation. And attachment of property, if any fine has been imposed as a nature of punishment, for that only the property can be attached. Equal valuable property can be attached under section 83 of CRPC. So here proclamation is that warrant of proclamation under section 82 can be definitely objected in family court itself.
Madam, I had asked a question based on 125, section 125 on FLW. This was on execution case. The court had ordered an FLW and directed the jurisdictional police station to attach movables. But the police officer, the SHO, actually arrested the person. So was this what he did was right?
Yes,
or
yeah, no, because the warrant has been issued not for arrest. Warrant has been issued for what? Only for the
warrant was for attachment of movables.
That's all. Sorry. The purpose of warrant is not for arrest. It is not the arrest warrant. It is the warrant to attach the property alone. So arrest itself, it is a clear case of violation of the warrant itself. The actual purpose of the warrant has not been properly executed by the concerned police officer.
So what is the remedy for this when such a thing
happens? You can challenge this before the concerned High Court itself. You can challenge the warrant of proclamation issued by the family court, which has been misused by the police. It is an illegal custody. It is an illegal arrest itself. It is not an arrest of warrant.
Okay, thank you.
Whether the person is in custody or has been released?
No, the person was taken directly to the family court, and then actually the main the court was on vacation, so an in charge judge compelled the person to pay a 1 lakh, and only then he was released. So actually the case was still sub judice. So isn't it a violation? That's what
one thing is that by taking arrest of the person, whether he sick, whether this person has to be signed by the person, whether he signed in the what the police will do cleverly to compel, as a compelling necessity, they will take the person into his arrest without formal arrest. Without making formal arrest with any of the procedures written from these procedures, they will take the person into his custody and directly produce him before this family court, and there they will fulfill whatever they want. So this is asking, execution of warrant is just check it out. In what way the warrant has been executed, in what way the executed warrant has been produced in the family court. Check it out, the nature of execution of the warrant. If it is possible, get a copy also, through which we can challenge.
Okay, thank you.
Okay, 217 is public. Thank you, sir. 217 is a public servant disobeying of law with the intent to save person, etc. So 217 is nothing but, sir, 217 is very simple. Some charge has been altered, and the person, again, suppose if I am being the witness, I already examined by the court. Again, the court now asking me, court in the sense either the prosecution side or the defense side, recalling me to come and stand as a witness for the particular charge which has been altered now. If I am being called by the defense side, what the defense will do, through my witness, through my statement, they will prove that no, there is no prima facie in the altered charge. If the prosecution has recalled me to come and stand as a witness before the court, the prosecution will prove that the altered charge is having prima facie. So here, with respect to this public servant disobeying of law with intent to save person, it is clearly and on its face a crime. It's an offense because it's from section 166 to 170. Because last week I covered that chapter in legal elites group, offenses relating to or against by the public servant. Public servant disobeying any of the law which he bound to obey is an offense. And if it is with a person, this can be. Just to elaborate, procedure after protest petition is not allowed. Not allowed is the only remedy is the section 482, sir. That's what the 482 is one of the finest procedure. We are utilizing is only for two purposes. One is direct the respondent police to register the complaint. Another one is to quash. Other than that, we can challenge all these things in 482. 82, 83, 82 and 83 issued together proclamation and attachment. Yes. The person has been proclaimed as an absconded or the person as an absent accused. Suppose he is being convicted and some fine has been imposed. Followed the proclamation, attachment of property can also be made. What is the action can be taken against a police officer for illegally arrest and illegal detention? Pathetically, the action against the police officer, suppose if I am filing habeas corpus petition to claim it is an illegal arrest, the court will ask the person to be released. But whether the police officer will be imposed with some compensation, it depends upon how I am making my case. Instead of habeas corpus petition, once the habeas corpus petition has been allowed, I can make another thing that it is a false, with an intention, with a malicious intention, this arrest has been made. If it is proved, I can claim compensation from the police, from the court or police. If arrest warrant could be executed due to fault of the person to be, could not be executed due to the fault of the person to be arrested, he may be declared a proclaimed offender. If execution could not be completed due to the fault of the police officer who had executed it, no, if the warrant has not been executed on the fault of the police officer, proclamation cannot be done. Because warrant has no limitation of time. They can take the time to execute the warrant. It is not a limited time. They have to take steps to execute the warrant, or else he can ask for the time. Simply because of the reason of the police officer, person should not be proclaimed as an offender. That's what section 167 says. Because of the delayed procedure of the police, why should an innocent person should languish in prison? You haven't completed your investigation. You are delaying the investigation. Why should the innocent person, in the eye of myself, should languish in prison? Release him immediately. That is section 166 class 2, 90 days and 60 days give the answer. Thank you. Thank you so much everyone for your kind cooperation. And again, thank you Beyond Law platform, because sir and Vijaylakshmi ma'am for this wonderful opportunity. Really, I want to say it is a wonderful opportunity for me, and I am really enjoy this, and it's a blessing for me. At the end of 31st of the New Year Eve, we have completed with this some fruitful way. Thank you so much, sir. Thank you everyone who participated.
So, thank you to all those participants who are watching us live on the Facebook and the YouTube, and also on this platform. And thank you, ma'am, for sharing your insights. And in fact, the Lakshmi ma'am had to leave, and she said that kindly express her thanks also. And the way you have expressed the things, I'm quite sure the persons especially preparing for the judicial exams and the students also would also be enriched, because the perspective of a professional and his teaching style is always distinct, and it goes in a better way, in a different manner, especially for the students. And tomorrow's session, on the 1st, we are starting off again. Topic would be concept of legal rights, characteristics of a legal rights, and types of legal rights, by Vishwanath V. Angdi, a former principal city civil and sessions judge, Karnataka. Do stay connected with us at 4 p.m. and Happy New Year in advance. And thank you for all the support. Everyone stay blessed, stay safe, and we hope 2020-21 would be a better year